Hello, good day. My name is Eliza Bayamishon, and I will be continuing the report of provisions from Article 1285 to Article 1289. Take note, this report is still under Section 5 of Laws on Obligations and Contracts, which is compensation. Just to refresh your minds, compensation, accordingly, is the extinguishment to the concurrent amount of the debts of two persons, who in their own right are reciprocally principal debtors and creditors of each other. In simple words, compensation only takes place if both parties have debts on each other. So just like the previous provisions, the one that we will be tackling will also circle around this idea. Let's start from Article 1285, which states that the debtor who has consented to the assignment of rights made by a creditor in favor of a third person cannot set up against the assignee the compensation which would pertain to him against the assignor, unless the assignor was notified by the debtor at the time he gave his consent that he reserved his right to the compensation. If the creditor communicated the cession to him, but the debtor did not consent thereto, the latter may set up the compensation of debts previous to the cession, but not of subsequent ones. If the assignment is made without the knowledge of the debtor, he may set up the compensation of all credits prior to the same, and also later ones until he had knowledge of the assignment. As shown, Article 1285 has three paragraphs or scenarios. First is when the assignment was made with the consent of the debtor. The second is when the assignment was made with the knowledge but without the consent or against the will of the debtor. Lastly, on the third paragraph is when the assignment was made without the knowledge of the debtor. So obviously, this provision talks about the effects of assignment on compensation of debts. As for paragraph 1, compensation cannot be set up because there's a consent and therefore a waiver of compensation for the debtor. Meaning, if the debtor has the knowledge and has consented the assignment, compensation cannot take place. However, an exception will be made if the debtor reserves his rights to the compensation. Here's an example to enlighten us all. Jake is indebted to Finn with 500,000 pesos. Finn in turn owes Jake 200,000 pesos. Suppose that both debts are already due and demandable, and all other requisites for legal compensation are present. Both debts are extinguished automatically up to the amount of 200,000 pesos. Later, Finn, with the consent of Jake, assigned his 500,000 pesos credit to BMO. The question is, how much can BMO collect successfully from Jake? So the answer is, BMO can collect the whole 500,000 pesos from Jake. So even though Finn has a debt of 200,000 pesos from Jake, still Jake cannot set up the defense of compensation because he gave a consent to the assignment. However, if Jake had reserved his right to the compensation, then he will only be forced to give 300,000 pesos to BMO. Is that clear? I hope so.
Okay.
Take note that if Jake gives his consent to the assignment before it was made or subsequently, then he loses the right to set up the defense of compensation. But he can still collect 200,000 pesos owed by Finn. In other words, the compensation shall be deemed not to have taken place. Now let's move on to the second paragraph. In this scenario, compensation can be set up regarding debts previous to the cession or assignment. Example, Finn owes Jake 1 million pesos due September 1. Later, Jake owed Finn 1,500,000 pesos, due September 8. And then, in another transaction, Finn owed Jake 500,000 pesos, due September 20. What happened is if Finn assigned his right to BMO on September 15. Finn notified Jake, but he didn't give his consent to the assignment. So the question again is, how much can BMO collect from Jake? Jake can only set up the compensation from the previous debts before the assignment. Hence, Jake can raise the defense of compensation with respect to his debt on September 8, which was before the assignment occurred. And since all debts has matured and the compensation has been made, BMO can only collect 500,000 pesos with respect to the 1 million debt of Finn. But Jake cannot raise the defense of compensation with respect to the debt of Finn that was due on September 20. because obviously it was made after the assignment occurred. So when the law says debts previous to the cession, it actually refers to the debts that has matured before the assignment or cession. Moving on to the last paragraph. So in this scenario, the debtor can set up compensation as a defense for all debts maturing prior to his knowledge of the assignment. So whether the debts matured before or after the assignment. This is not a factor. The crucial time here is in the time of knowledge of the assignment and not the time of assignment itself. So how about we go back to our example from the previous scenario?
Ta-da!
What if Finn did not notify Jake about the assignment made on September 15, and Jake only knew about the assignment on September 25? Because the crucial time is when Jake knew about the assignment, and because all obligation has matured already before he knew about it, in this case, Jake can set up a compensation of credits for all debts either before or after assignment occurred. That's it. So much for Article 1285. Let's move on to Article 1286, which states that compensation takes place by operation of law, even though the debts may be payable at different places, but there shall be an indemnity for expenses of exchange or transportation to the place of payment. Actually, this article applies to legal compensation. I'll explain the first part. Indemnity for expenses of transportation, this one applies to the transportation of goods or object. And if you say indemnity for expense of exchange, it refers to the expenses for the monetary exchange if, for example, the debt is in dollars. Here's for enlightenment. BMO owes Finn $1,000 payable in New York, and then Finn owes BMO 100,000 pesos, an equivalent amount payable in Manila. So if BMO claims compensation, he must be the one to pay for the expenses of exchange, the same as with the expense of transportation. So it only means that whoever claims the compensation must be the one responsible for paying the expenses of exchange or transportation. That is Article 1286. Next is Article 1287. Article 1287 states that compensation shall not be proper when one of the debts arises from a depositum or from the obligations of the depositary or of a bailee in commoditum. Neither can compensation be set up against a creditor who has a claim for support due by gratuitous title, without prejudice to the provisions of paragraph 2 of Article 301. This article talks about instances or situations when legal compensation cannot take place. Here are the compensations that are not allowed by law: depositum, commoditum, support, civil liability arising from crime. To make it clear, let's first hear the definition of each. Depositum is a special real contract whereby the depositor entrusts to the depository something for safekeeping. Please do not confuse with the bank deposit, because that one is actually governed by the contract of loan. Going back, in depositum, there is a bailment created which imposes upon the depository the duty to return the property. So the depository does not even have the right to use it. For example, Ice King deposited in Princess Bubblegum a 100 sack of rice valuing 100,000 pesos, and then later he owed her 1 million pesos when Ice King tried to withdraw his 100 sacks of rice from Princess Bubblegum. She refuses to deliver, and she is actually claiming for compensation. This is because Ice King owed her 1 million pesos.
Oh no!
The question is Princess Bubblegum allowed to compensate? Obviously no. She cannot refuse to deliver claiming compensation because this is an obligation arising from deposit. Hence, compensation shall not be proper. Here's another example. Ice King deposited on his bank 100,000 pesos, but later on he had a debt of 10,000 pesos. Question: can the bank set up compensation? Yes, deposits in bank are governed by a contract of loan, not a contract of deposit. Just like what I said earlier. Now the depositor is actually the creditor and the bank is the debtor, so the bank can set up a compensation. On the other hand, commoditum is a gratuitous contract whereby one of the parties delivers to another something not consumable so that the latter may use the same for a certain time and return it. For this reason, The borrower cannot retain the thing loaned to offset something to lender may owe him even though this may be for expenses. For example, Flame Princess borrowed the guitar of Marceline the Vampire Queen, but actually Marceline owed her 1 million pesos. Later on, Flame Princess must not refuse to return the guitar just because Marceline owed her money, for no compensation can take place when one of the debts arises from a commoditone. Next is when one debt arises from a claim for support due by gratuitous title. Now, the right to receive support cannot be waived nor transferred because support is necessary for subsistence and the right is purely personal to the recipient. For example, Ice King is the father of Ice Princess, a minor who under the law is entitled to be supported by Ice King. What happened is Ice Princess owed Ice King 1 million pesos. Ice King cannot compensate his obligation to support Ice Princess by what she owes him because the right to receive support cannot be compensated. In simple words, Ice King must not refuse to give her allowance or give support just because she owes her money.
Bruh.
Moving on to next provision. Article 1288 states that neither shall there be compensation if one of the debts consists in civil liability arising from a penal offense. So when the debt proceeds from a criminal offense, the debtor shall not be exempted from the payment of the penalty, nor from the indemnity arising from his own crime. You should take note that any compensation of debt arising from a penal offense is improper or inadvisable because the satisfaction of such obligation is imperative. However, the offender is the only party who cannot set up the compensation. The offended party who is entitled to indemnity can set up his claim in compensation of his debt. In short, there is no compensation if one debt arises from a crime. Take this for example. Finn and Princess Bubblegum are lovers and Princess Bubblegum owed Finn 100,000 pesos. Later on, the two of them fought and Finn has inflicted physical injuries against Princess Bubblegum. Because of that, Princess Bubblegum filed a case against him and then the court rendered judgment in favor of Princess Bubblegum, ordering him to pay her 100,000 pesos. So, again in this case, Finn cannot claim compensation with respect to Princess Bubblegum's debt. Still, Finn must pay Princess Bubblegum the 100,000 pesos ordered by the court. However, the offended party can claim the setup of compensation. So only Princess Bubblegum has the right of compensation. Now, we're finally down to our last provision, Article 1289, which states that if a person should have against him several debts which are susceptible of compensation, the rules on the application of payments shall apply to the order of the compensation. So as said, there are rules on application of payments applicable to order of compensation. Compensation is similar to payment. So if a debtor has various debts which are susceptible of compensation, he must inform the creditor which of them shall be the object of compensation. In case he fails to do so, then the compensation shall be applied to the most onerous obligation. I look up the definition of onerous, and well, it refers to the most unpleasant or difficult to do or deal with. For example, Jake is indebted to Finn in the amount of 10,000 pesos without interest due today and 10,000 pesos with interest of 12% due also today and another 1,000 pesos with interest of 10% due yesterday. Now Finn owes Jake 10,000 pesos due today. For purposes of the application of payment, Jake is a debtor. He must specify to Finn which of the three debts should be compensated. If he fails to inform Finn, then the latter should apply the compensation to the second obligation of Jake, namely the obligation bearing the 12% interest because it is the most onerous obligation. So that's it. This ends my report. Thank you for listening.